Okay, good morning, everyone, and welcome to another Wednesday morning online seminar with Silver Shemmings Ash. Today, we are joined by Mohammed Haque, who's a barrister, adjudicator, and quantum expert, and he's going to be talking to us about leave site now and don't come back, termination, and other unpleasant things. So, Mohammed, I will give you the floor, and as usual, if you've got any questions for Mohammed, please put them onto the Q&A or chat tool in the bottom toolbar, and he will get to these at the end. Okay, Mohammed, over to you.
Sure. Thanks, Julie, and morning and welcome to our breakfast seminar session. And what are we trying to talk about in this session is the party's right to terminate a construction contract. Essentially, one of the parties to stand up, might try to stand up and say that I don't want you anymore. And although in vast majority of cases, generally the employer does so, or do so, employers, but it's not necessarily to be the case always. It could be a self-sided declaration by the contractor to leave the site in times of difficulty. And it could be an internal decision that let's leave the site and we'll not come back again. Now, once a contract is entered into, it has to be brought to an end. The respective obligations of the parties must be performed, and that's the best way to bring it to an end. But it is not necessarily the only way to bring a contract to an end. A contract could be frustrated, and due to the frustration, the parties may be absolved from performing the contract any further. As I already said, it could be performed fully and done and dusted. Alternatively, the contract could be brought to an end before it's completed or performed by the parties. And if that happens, we call it that the contract has been terminated. And the termination could be of various different types. Obviously, a termination it could be, as we sometimes call it, simpliciter, meaning at convenience or at will of one of the parties. Now, this is not provided by law at all, at least for the case of construction contracts. A common law is not possible. It can only be possible to bring a contract to an end in advance of its performance by agreement, and the agreement to bring a contract to an end for nothing and the consequences thereof could either be expressly agreed and such a term could be included into the contract, or it could be that because, let's say, the COVID prolongs and some projects are no more possible to be achieved, so the parties might decide to come together and take a decision that let's call it a day, we can't perform or we won't have the project anymore. In such situations, of course, parties also agree a compensation package, but all in all, these are by agreement. However, the focus today is on the right to terminate a contract, a construction contract, because there is a breach by one of the parties, and the innocent party do have a right to terminate in such scenario, provided the breach is sufficiently grave, and there are other conditions there as well, and we'll discuss about that. And obviously, a termination could be an event prescribed by a particular statute as well. For example, some contracts would provide, and earlier it was there that insolvency could result into termination, death could result into termination. Similarly, we have the common law rights, and today we'll be discussing more on the common law rights, and also we'll touch upon the express terms of termination, normally which we find into the model form contracts like NEC, JCT, and so on and so forth. So that's the scope of the discussion. I go to the first slide. That, as I said, my focus should be to be on the right of the innocent party to terminate a contract arising out of a breach by the other party to the contract. So this type of termination presupposes that a party, the innocent party as we call it, the victim of the breach, will decide that enough is enough, I'm not happy the way you are performing, please go away and I will go to someone else. Now, termination is a serious call to be made. And as such, the breach must be, in order to justify a decision like that, breach must be a serious breach. Sometimes we call it, the contractual terms sometimes, from at least one perspective, I would say, are grouped into two groups: conditions and warranties. Warranties are minor terms, and the breach of which can be compensated. But if there is sufficiently a serious term, which we call the condition of the contract, in that case, the breach of even a minor breach of the condition may result into a right of the innocent party to bring the contract to an end or terminate. Sometimes we say that the breach of a fundamental term or a repudiatory breach, which is a sufficiently serious breach of a condition, would result into a termination or allowing the innocent party to terminate. The difficulty is that although it's easier to formulate what is a or state or describe or define what is a repudiatory breach or breach of a fundamental term, sometimes it's very difficult to classify a term as fundamental unless, I say post facto, of course, unless it's been already classified by the parties expressly as a fundamental term. In other words, what I'm trying to say is the difficulty is, in most likely cases, nobody calls that, okay, these terms are fundamental terms, and if this is not done, I will be able to repudiate the contract. It's not said as such. The list is not provided within contracts, and as such, what happens is, after a breach, the party the innocent party who's trying to repudiate, trying to terminate the contract, they turn around and say that this is the breach of a fundamental term, and the guilty party always say, no, it's not a fundamental term, it's actually a warranty. So the problem is there rather than defining. But having said that, the contract obviously is a free document between two parties. It's been entered into voluntarily. So if the parties sign up to something which clearly says that a tiny breach of this or a little breach of this is a breach which will allow me one party or the other to terminate, then that's it. I mean, there isn't a hard and fast rule that a particular term cannot or can be classified as a fundamental term, and there isn't a particular breach which can be which can be said as a sufficiently grave one, because if the parties have treated it as such. Now, one example I give you, in a seller goods contract, the date of delivery is treated as a fundamental term. So, for example, if something is supposed to reach you on to be delivered at site on a particular date, and that doesn't happen, under the sale of goods law, you have the right to say that I'm not gonna accept it. That's a very clear line drawn in sale of goods law. But come to construction contracts, what happens if there is a delay? We know that the delays are compensated, or the delays, the completion dates are either revised, or we give have provision within the contract under which we pay acceleration costs and so many other prolongation, loss of recovery of expenses and all of these things. What does that mean? Obviously, that means the breach of that term, unless sufficiently grave or severe or serious, one cannot say that just because there is a delay, there is a breach of a fundamental term or repudiatory nature, so the innocent party will have the right to terminate it. So despite something is called as a fundamental term, a condition or whatnot, it could be, unless you specify very clearly that regardless of the other rights of delay compensation or whatever into this contract, every single minor delay or a breach in that respect could be treated as a breach of fundamental term or a repudiatory nature, so that the innocent party will have the right to terminate. It becomes difficult, to establish that because of this other term. So sometimes even to decide whether the breach is a breach of a fundamental term or breach of a repudiatory nature, you have to consider the contract as a whole and not a term in isolation. And if it could be established that the parties actually have intended to be happy with damages and damages alone, that could be a fatal consequence regarding your right to terminate. Now, of course, having said that, I will give you some examples of when does a termination become possible, because if one of the parties, let's say the employer, says out of nothing, for nothing, that I don't want you anymore. You are slow. We know in construction it happens. You are slow. Your mobilization is not up to the mark. This and that. So go away. I don't want you anymore. And it could be that what happens, the employer finds, or at least advised so, that hang on a minute, for this bathroom extension, you're paying 30,000 or 35,000. This isn't possible. It should have been done by 10K or 15K. And the employer, being impressed by this advice, decides, okay, fair enough, I will terminate the existing contract. No, you cannot. It's not a right you have at will. However, if such a thing is done, it is in itself a repudiatory breach, okay? And I will come back to this aspect, that if something like this happens, what can the other party do? Now, in a construction contract, the scenario is that one party wants something to be constructed, describes it, and a time is also defined for that you have to do it during this period. Okay. Now, normally the contract is signed, that's at least expected, that the contract is signed before the commencement at site. So one party could, even before the commencement, stand up and say that I don't want it anymore. So this could be one time slot when you can terminate the contract. And then once the commencement is done and the contractor starts performing, or subcontractor starts performing, if the contract is between contractor and subcontractor, the contractor's entitlement, the one who is performing the contract in the sense that constructing the scope, entitlement is to get paid, And historically, the common law always took a position that unless there is an express term saying so, that failure of a payment at the due date, the contract can be terminated. The breach itself is never treated as a repudiatory breach entitling the other side to terminate it, because an interest can be paid, and the innocent party is pretty much entitled under the common law or the statute interests, and that's a sufficient compensation. So there isn't a repudiatory breach just because 1, 2, or 3 payments are missed. But if it becomes habitual, then that's a different thing. Now, it's just a repetition of the earlier sentence that normally a failure to payment or pay less than what you're entitled to, or paying it in installment, is not in itself a justification to terminate. Although if it's a construction contract to which the HGCRA applies, the Act 1996, then you have a right to suspend the contractor, but it's highly unlikely that that can be treated as a ground to terminate the contract. Now, again, about the completion date, every construction contract has an end date, which means the practical completion normally defined, and then a defect liability period is defined, and then a slot by which the defects, as finally determined by the end of the defect liability period, is to be rectified, and then a final certificate comes in. Now, it so happens quite regularly that the project overruns because variations are instructed, and parties fail to revise their practical date of completion. And then sometimes the employer has taken advantage of saying that the contract has overrun, so you have failed to complete it within time and I'm terminating. Again, it's not so easy, as I said, because it's a complex issue. It could be that you have some entitlement extension of time, and that has not been disposed of. So the contract is, time is running at large, and as such, your attempt to terminate it may fail. So in the absence, again, in the absence of a clear expression that a particular date, if missed, the other side will have the right, regardless of other rights of the contractor, to terminate it. It's not so easy like other contracts, like sale of goods. So bear it in mind that it's not to be used as a tool at your will. It's something very difficult to achieve. Now, one scenario, like, although a particular breach is not very serious, and it sometimes happened during the defect liability period, and some people might think, oh, the contractor has completed the contract, and we're in the defect liability phase, can I terminate? Oh, yes, you can. In a scenario where there are defects found, and that becomes contractor's responsibility under the terms of the contract to be rectified within a given period of time. If the contractor fails to, after getting the notice to be to rectify the defect, or repair it or remove the defect, whatever way you call it, there is a good chance that you can, the employer can terminate the contract. But one thing happens, without terminating sometimes the employers, they go to a third party. Never do that. Never do that, because if you do it, then that contractor will come back and say, "Oh, I was supposed to come. I was ready and willing and prepared. I was just busy, and I still had time to do it. So you didn't have any right whatsoever." And that might even hamper the employer's right to recover damages. Now, I've already discussed it, that if somebody is like doing habitual or repetitive mistakes, which goes to the overall quality of performance, which makes the employer feel that the contractor is not possibly of any competence, although the bar is high. But if you have a long list, the employer has a long list of breaches, tiny ones, repetitive, not changing despite giving given notices, then the combined effect of smaller breaches may result into a right, though each of them taken independently is a very minor one, could entitle the employer to decide that, no, I'm no more interested, I will terminate the contract. Now, if, for example, one of the parties, for example, the contractor, 80% job done, and then they say, don't, I'm not interested to do the rest. And it could so happen for the employer as well. I've very recently sat on an adjudication where almost 75% works were done, and then there was a problem as to one line item in a £1 million contract, one line item of £12,000 only. And mind you, that was during the period of COVID. And they were discussing that the contractor will restart, and then all of a sudden the employer said, you have to do it within 9 days. If you don't, then I'll see what I can do. And then eventually the employer said that I'm terminating. In this sphere of 7 days or so, they said, I'm terminating. And although the contractor has accepted the repudiatory breach, elected to accepted the repudiatory breach, they have made a claim. And that I was sitting on an adjudication, and the contractor was saying this was repudiatory breach. And the argument was that no, only 20%, 30% of the works by quantity and value were left out. So how can I say that this is repudiatory breach? But the very statement that don't do it anymore without a proper justification, because in £1 million contract, if there is a little delay in performing an item which costs you 12,000 and not so critical for the delivery of the whole project, it was difficult for them to argue successfully, and they lost their case. So please never ever, just because you dislike or just because you feel that you can employ someone else more profitably, don't turn around and say, don't do it anymore. Just because you are wrong here, I'm deciding that you are of no competence and go away. It's not a good idea. Now, I've already discussed this, that contract is a free thing to do between two parties. So if it's been classified that clearly within the contract, that no matter how small, little, tiny breach of this is, I'm not going to accept it. I'll give you an example. This didn't happen in England, but one of the parties, the contractor was from England, so it was decided in England. The case that has followed was decided in England because English law was applicable, and the forum was England. A particular shade of a glass panel was very important for the building. Okay, whatever bottle grain was there. this was a building of national importance. On a national day, they were supposed to inaugurate the building. So all lined up, and what happened, it was found that the shade that was asked for was not been set. The panels were of slightly different color, but it was so vividly described, the description was so clear that the employer was decided to have the right, because they made it very clear that unless the glass panels are of this shade, we're not going to take this building. So that's what it is. If you think that something is very important for you into the contract, please set that clearly, and please state within the contract document that if this doesn't happen, I will have the right, the slightest breach, I'll have the right to terminate. And in that case, obviously, you can, no one can stop you, no matter how silly the breach is from an objective perspective. Now, I've already stated that you can use, rather than giving a name and thinking, all right, this is going to allow me, in case there is a breach, I can repudiate or call it a repudiatory breach and terminate the contract. Please do not think as such, because it's not a clear-cut evidence that just because a term is called condition or a condition precedent, for example, JCT, you have got the preambles, the articles, the particulars, and rest are all conditions. There isn't any warranty as such. If or any term has not been, none of the terms have been classified as a warranty at all. However, we know that there are so many terms in JCT included into the conditions, but they are actually warranties. So it doesn't matter by what name you call it. If the safest way, if you really think something is important so much that if it doesn't happen, you will have the right to terminate, please clearly state that in your contract. Now, if there is a clause which says that, I've just given you the example about the glass panels, that if it says that we are trying to achieve such and such thing, and if it doesn't achieve, if you don't achieve it, you will have the consequences, and I will terminate. So unless there is a very good justification, it won't be in the hand of the breaching party to say that no, this is minor. So just the same thing being repeated. Okay. Now the next thing is the election, affirmation, whatever way we call it. So we are discussing the scenario where there is a repudiatory breach. Obviously, this is not an obligation, that if there is a repudiatory breach, you have to terminate it. No, there isn't anything like that in a contract. It is entirely a choice by the innocent party. So he may decide to say that, fair enough, although I'm very irritated and annoyed, doesn't matter. On the whole, he might think, if I replace now, if I terminate now, it'll be more difficult, and which is a very good thinking, to bring another one and get the things done, okay? And as such, he might decide to say, okay, fair enough, I will elect to continue with this party. This we call, the contract has been affirmed by the innocent party. One thing to remember, just because the innocent party has accepted the breach from the perspective of termination, it doesn't mean that he loses the right to seek damages. So even though somebody accepts the breach and decides to continue to call for the performance, he still holds the right to seek damages. Now, it's not so not so easy a thing for the guilty party, especially that to say that no, you can't repudiate now, although the breach is serious or is terminable breach. You can't do that because you have accepted it. It's not an easy argument from the guilty party either, because unless there is a clear by conduct or by express words of mouth or written notice that I will not terminate, and I ask you to continue regardless of this breach, unless something like that can be shown by words of mouth, by the guilty party, of course, or by conduct. It's the right to terminate is not lost, and affirmation is not so easily construed either. So that is something, if you are the guilty party, you have to keep in your mind, as it says that a party will not be held to have elected the firm unless he has the knowledge of the fact giving rise to the breach. So, so that is also a thing, that if there is a breach, it may so happen in the world of construction, where the site is run by third parties like architects and others. It's contract administrators, employers, agents. It sometimes doesn't come to the knowledge, and you will see that even if a works is taken back, it doesn't matter. It could be that later on it's found that there is a problem with the work, and if that is a sufficiently problematic thing, it's a serious breach, then when the knowledge comes to the mind of the employer, and if the contract is still alive to be terminated, he has the right to terminate. And so that's a vital factor to be taken into consideration, the knowledge of the innocent party. I've already said, although it's difficult for the guilty party to argue that the breach has been accepted, but it doesn't always have to be expressed. The affirmation, it could be by conduct as well. For example, in a meeting, something has been discussed, and then a conduct is there from the employer, which goes to show that the breach was really minor. So in the mind of the employer, then that conduct may be a good justification to argue. But again, I do remember that it's not so easy to sell this type of arguments because you are the guilty party. Now, well, I said that already, that by conduct or by express, and then, yeah, I mean, also to remember that if just because there is a time gap between the breach and the action, and other acts were asked to be performed, it doesn't on its own makes it an acceptance. So unless, or affirmation, unless there is a discussion and a conclusion by the parties that this is, regardless of the breach, the employer wants to, or the innocent party wants to continue, you may have difficulty in establishing that. So if I kind of draw a line, it is difficult for the innocent party to establish that the breach was so sufficiently grave, unless that has been defined, that this is the only consequence or the preferred consequence for the innocent party. It's difficult to establish a breach to be a repudiatory breach. Similarly, if there is a repudiatory breach, the innocent party would always struggle unless he has clear and unequivocal evidence. The innocent party would always struggle to establish that, oh no, although there was a breach, a repudiatory in nature, from my end, you have elected to affirm. Now, if in a situation both parties are guilty of repudiatory breach, which one prevailed earlier in time will prevail. Remember this rule. Now, what will happen after termination? The innocent party will be released. To be honest, both the parties will be released from performing the contract anymore, but the innocent party will have the right and entitlement to claim damages. And obviously, if it is the contractor, then he has a right to claim the loss of the opportunity to perform the contract. Now, just because sometimes people get very excited if contract is terminated, I've seen contractors that it seems like they start thinking that they have the right to the whole world, to earn a big fortune out of it. No, that's not the case. And sometimes the quantum, although you have the right to recover, the quantum to be established is difficult, because if a contract is brought to an end earlier, you have some savings on the prelims. And if the prelims were going on time basis and the contract was overrun, you will always have a difficulty in establishing your losses. And then you have, for the loss of the opportunity of the rest of the works, you got to establish that the profit percentage, of course, that's going to be a gross profit rate, not a net profit rate, that this you have lost. And if in dealings with this termination before the end of the contract, if you have had some extra time on overheads and loss of head office overheads. I mean, sometimes this is again, contractors become very confused, because remember, in a construction contract, the site overheads are consumed under the preliminaries. So that's something. Keep in your mind that it is not so easy to quantify the losses. And finally, the termination works prospectively. So if you've got insurance liability and others, up to the date of the termination, you're still responsible, and your insurance can be called on that for your other breaches or the same breach which happened prior to the termination. So yeah, I've already discussed this rights acquired before discharge, and I'll be coming to the point of model form, but just a reminder that what can and cannot happen upon termination. I find that, or it's my preference, that NEC contract has a very clearly defined clause and kind of a schedule which says that these are the consequences, this is how you are going to get your money and things like that. So that can be used as a general concept for other contracts as well. Of course, you have to readjust it to the particular form you are working on. And but the rule is the rights acquired before the discharge is pretty much an entitlement. So it cannot be retained. So for example, if there is a notified sum to be paid, the employer still has to pay it, and on the ground of set off, he cannot hold it, and so on and so forth. And also the adjudication arbitration provisions in contract, generally, even after termination, it continues. Sometimes what happens if you, a model form like JCT that says, upon termination, you are only entitled to the proper value of the works already executed. I've seen in the past people trying to take it as an advantage of revaluing the works done at the market value. No, that's not the case. The proper value is the value which is agreed into the contract. And as such, if something has been done and you have paid for, it's highly unlikely that you can then say, no, this was not the proper value, the market value is different. So the last thing is, if it's under the express terms, which is, of course, as the case may be, sometimes the common law is supplementary, so it's the common law rights are not lost, but as a starting point, of course, you'll be getting the defined ones within the contract, within the express terms. Now, normally in standard forms, we sometimes have the employer's right to call it a day anytime he wants to at his convenience, unless it's a consumer contract, and the contractor cannot be a consumer in normal cases. It's difficult to argue that this was an unreasonable clause because it's a business contract. And if it has been bargained properly, that's it. It's an informed bargain and you have to honor it. But obviously, it's quite common that it's stated that this is a power the employer will not use unreasonably. And also you will find that there are stringent notice requirements, and also sometimes if it's a termination on default, it's stated that the guilty party should be given the opportunity to rectify or remove or repair the problem. And it's been clear, like in JCT, it says it shouldn't be used unreasonably or vexatiously, meaning you cannot use it with an ulterior motive to oppress or harass the contractor. It has to be, the exercise should be reasonable. It should be something which has a proper contractual justification. And if the contract also says that this termination clause is not exhaustive, it is without prejudice to any other rights and remedies. If there is anything like that within the contract, that means the common law rights are still retained. So it's not the only way or only a right the innocent party has. Even though an express termination clause is there, the party may decide to terminate it under the common law. And remember that the clauses of termination or any forfeiture of retention or anything like that are strictly construed against the party who is trying to enforce it. So be sure that every single step, the time of any notice required, the content of the notice as asked for, is drafted, particularly taking it into very seriously, so that it complies the provision in all respect. Otherwise, it could be that a third-party tribunal may decide that although you had a preliminary right to terminate, you failed to follow the procedure. So it's always the tendency that unless there is something akin to the common law repudiatory breach, it might be that you use a procedure and you fail. So that's again another thing. And I think that's all. That's all from me. Well, time was not too bad either.
Okay, we've had some questions in, so that would be great if you could answer some of these. Sure. Someone's asking, how should the below be handled? A contractor terminates the contract due to late payment by the client on 3 to 4 occasions and walks off site. Suppliers and subcontractors are not paid, but have completed their work up to about 80%. How would you deal with that one?
Well, I mean, there is a technical legal answer to it, and there is a practical answer to that as well. The suppliers and the subcontractors not been paid, and the contractor has taken the advantage, bagged the money, and left the site knowing fully well that it will go burst, so you can't even recover the damages, is just playing at it. Now, you may be frustrated, but you have no choice or anything to rely on from a very practical perspective. The very recent solution to it, I was involved in it when it was first discussed at the Parliament. I was involved with the process, is the project bank account. You know, the concept is, and NEC has introduced it now, the concept is that you ask your contractor, that's of course the prospective, I can't give you any practical solution to what has already happened, because the suppliers and the subcontractors do not have a right to ask for money from you directly anywhere, for the simple reason that there is no privy, they aren't the privy to contract to you. Their contract is with the contractor, so you can simply say, thank you very much, go to your contracting party and recover, we are nobody to do anything. However, from a practical perspective for future kind of solutions, the project bank account could be a solution where the respective rights and the subcontractors are all included, and that money should be declared and kept ring-fenced, so the contractor cannot take it away. And in any case, failure on the employer's part not to pay 3 or 4 occasions, unless defined clearly that the contractor has a right to do so, it's normally not a remedy, it's not a repudiatory breach, because failure to pay can be compensated, you know, by paying either the contractual rate of interest or by the Late Payment Act. So that's 8% plus the Bank of England rate. So it's never, I would be highly surprised if missing 3 or 4 payments will be. However, under the Housing Grants Construction Regeneration Act 1996, without going into the detail of your factual pattern, there might be something in it which entitles the contractor to do so, but they have a right to suspend. The contractor has a right to suspend, and they have the right to recover any losses due to suspension or any extra expenses due to suspension, and they have a right to get extension of time as well. But the English law, as it has been always, late payment is not a clear justification or a repudiatory breach normally. And I can just from my memory, I can say you up to 3 payments have been decided by House of Lords, missing 3 payments, not sufficient enough that the employer has no intention to pay anymore. Yeah. So as I say, technical and legal, one side, and practical is slightly different. Yeah.
Someone else is asking, could you please touch on termination of contract and termination of employment under the contract and the effects or consequences of both?
Well, I'm not very clear about your question, first of all. Termination of employment
under the contract.
Are you talking about any particular office under the contract, which is under employment law, and termination of that, as opposed to termination of the contract, meaning that when we are talking about termination of the contract, we are talking about clearly 2 parties, regardless of whatever other architect, administrator, quantity surveyor is involved in it. We are talking about a relationship between an employer and the contractor, or a contractor and the subcontractor. And as you have discussed, there are only 2 options. It could be that an agreed term is included and declared as exhaustive or final. There isn't anything else you can go to terminate the contract. Or it could be that the common law rights, one way or the other, is still there, which means one party is in repudiatory breach, which will entitle the other party either to elect to continue or to terminate. But if, for example, within the contract, there are some, say, office of the architect, but if you are terminating the employment of the architect or the contract administrator or QS or whatever, that actually doesn't come under that construction contract between you and the contractor. It's a separate relationship, and you do as you do. But if you're the employer, you've got to provide and continue to have that office. Similarly, for example, under the latest model form of JCT, there should be a bill of clerk, or I think in NEC there has to be a similar officer on site from the contractor side. Now, just because the contractor terminates that employment, it doesn't become a termination between the employer and the contractor. It is an obligation for the respective party to have somebody into the office, okay? But if you terminate it, you replace it, whichever party terminates that contract.
Okay. Someone else is asking if you could clarify if termination is possible where conditions precedent is breached.
Well, as I said, sometimes for non-lawyers, terminologies are a great thing. But first of all, just because you call something as a condition precedent, it doesn't become a condition precedent. You know, it has to satisfy the most famous statement from Lord Diplock, obviously in a different sets of cases, was about lease and license distinction. But I always use this in Street v. Mountford in House of Lords 1986, as it used to be called, now it's the UK Supreme Court. Lord Diplock said, you might as well decide to call your pet cat a dog, or little doggy, but that doesn't make the cat a dog. So when it comes to law, it has to be a condition precedent first. Now, if it is a condition precedent, as per the law, and which has some uncertainty as to what is to be called a condition precedent and what is not. So if it is so, then yes, the breach of it is a repudiatory breach. But what is a condition precedent or not is a difficulty. That's the first thing. And secondly, as I've discussed, just because a term is called a condition precedent, it may be so that there are other terms within the contract which provides a sufficient machinery to recover and solve the point with damages or other solutions. And then although it's sitting within the list of condition precedent, it could be that the innocent party will lose the right because of the implication of some other terms of the contract. So there isn't a general answer to it. It's best that you have to look at, because the final point is this a repudiatory breach? You know, that's what is the sort of cornerstone, if you would so like. Yeah.
Okay, another question here. Within the 1996 Act, there is a right to suspend. After how long can the contractor who has suspended terminate?
Well, actually, there isn't anything said into the Act, first of all. So technically speaking, we do not have an answer, but we have to go to common law. Common law says that if it becomes apparent from habitual default of non-payment that the employer is no more willing to pay or is not been able to pay, in that case, you have a right to. So it's not a question of how long, it's a question of what is the position of the employer. If you could, which is of course is a point of fact that to be proved, and he will struggle with evidence, but it is how you manage, you know, that how you are chasing him and how you are holding meetings with him, trying to find out what the problems are and why they're not paying. Now, if you have sufficient evidence to prove that the employer is no more going to pay at all, it may happen within 15 days, within 10 days after your suspension. The employer might clearly send a letter to you. Now you have suspended, you see, I'm never going to pay you. it could be on the next day. And you say, oh, okay, thank you very much. Then I don't have, I'm demobilizing. So it's something like that. But then again, I would say, unless it's a very small contract, construction contracts, you know how difficult it is to win or sign a construction contract. So don't make it like an emotional decision. From my 25 years experience, I would say, do continue if that's possible. And also don't forget, just because you suspend, the works at site, you win everything, because you may have continuing other liabilities like insurance, which you have to keep alive. So these are very complex decisions, and I would say don't take them emotionally. If you're feeling emotional due to some hormone or anything else, please go to an advisor. You know? And don't go to an advisor who gets excited. And yeah, because
I believe the advice here is take the emotion out of the decision, is what you're trying to tell us.
That's what I'm trying to mean. You know, but there are advisors who gets equally emotional. You know, no, how can they do that? I can't believe it. You know, don't, if someone's doing like that, please, he shouldn't be your advisor.
Yeah. Okay, point taken. Right, that's great. That's all the questions that we've had in so far answered. So thank you very much for that, Mohammed. Thank you for your time as always. And you're back with us tomorrow night, aren't you, in the latest of your adjudication matters?
Yeah, my adjudication matters one, yes.
Yeah, that's at 6 o'clock, and we're talking about evidencing a claim, proving and evidencing a claim. So if you'd like the login details for that one, please email seminars@silverllp.com. And we're also back online tonight with Richard Silver in the latest on his Construction Essentials series, where he's talking about programming and planning. So again, if you'd like a seat on that, please give us, drop us an email, seminars@silverllp.com. In the meantime, as you can see on the screen there, if there's anything specific you wish to speak to Mohammed about that you didn't particularly want to raise in an open forum, please feel free to email him directly, Mohammed Haque @silverllp.com, and he'll be delighted to answer your questions. So thank you again, Mohammed. Thank you, everyone.
You're welcome, and thanks everyone for joining.
Have a great day, and we'll see you again soon. Thank you very much.
Bye-bye.